Number 77, Chen versus Insurance Company of the State of Pennsylvania. Counsel?
Kenneth Gorman for the plaintiff appellant. I'd like to reserve 2 minutes for rebuttal.
You may, sir.
Thank you.
You're welcome.
Do I begin?
Please proceed, sir. Yes,
okay.
Please.
The procedural problems of this case simply cannot be overlooked. I mean, with regard to the issue of waiver, there's no dispute that the plaintiff has always sought statutory interest, which included prejudgment interest that was already factored into the judgment and all post-judgment interest. This was made clear in plaintiff's initial demand letter that was sent on October 31st, 2013. It was made clear in plaintiff's complaint. It was made clear in plaintiff's amended complaint, and it was made clear in a motion for summary judgment. ISOP waived this issue by failing to address it when it opposed plaintiff's motion for summary judgment. This is the only reported decision in the state of New York, and I can't find any decisions outside of the state of New York which applies the concept of a contractual waiver in a litigation context when opposing motions made on notice. And this decision has the potential of overturning or at least significantly transforming the decisional law regarding the legal doctrine of waiver. With regard to re-argument, granting ISOP leave to re-argue issues that were not previously raised prior to the entry of the final order is contrary to the plain meaning of CPLR 2221D and the decisional law from every appellate court in the state of New York. This court held in Simpson versus Lohman and Riley versus Steinhardt that a motion for re-argument cannot be used as a vehicle to advance new legal theories that were not previously asserted.
But aren't we really dealing with here with the court's perception that there was a mistake in law?
I'm sorry, could you repeat that, please?
Sure. These masks make it hard sometimes for all of us. Aren't we really dealing here with the CPLR question of whether there's a mistake in law on the court's part? And a court always has the right to go back and address a mistake in its legal analysis.
That's right, but I mean, there was no mistake in law here. I mean, ISOP didn't even mention the word interest in any of the papers that were submitted in opposition to our motion for summary
But it argued it did drop down. Sorry. It argued, right? It did drop down.
Argued that it dropped down with regard to the $1 million limit. I mean, I'd just like to refer the court to ISOP's when ISOP opposed our motion for summary judgment, it acknowledged at page 389 of the record that the judgment was $2.3 million and that it had nearly $400,000 of prejudgment interest factored into it. And at page 333 of the record...
But weren't they, isn't that what the focus of the arguments was? It was the drop-down issue, and it seems to me like they never really, nobody ever really got to talking about interest in particular. The focus was on, did they have to pay the whole amount or didn't they? And then once the court said, no, they didn't, then the allocation of who was responsible for what interest really came to light. Isn't that what happened? I mean, I know that your references to the record are accurate and all of that, but it doesn't demonstrate really what the nature of the discussion was, and I think the context of it has to be taken into account, doesn't it?
No, I mean, when ISOP opposed our motion for summary judgment, it said, and I'm going to quote what it said, if ISOP is liable at all, it is liable only for the amount of the judgment, which it acknowledged included prejudgment interest, less the $1 million limit. Not less the $1 million limit and the supplementary payments, just the $1 million limit. The issue of interest is governed by the contractual language. And so there was no reason
let me ask a question on that, on the interest question, your response to Judge Stein. Is your argument that the follow the form requirement means that post-judgment interest goes back to the primary policy, the excess policy, of course, will cover that, so the post-judgment interest would be on the full 2.3?
That's correct.
All right. And that's based on a follow the form argument, is that right?
That's correct.
All right. just so I have it clear. Thank you.
Okay. If ISOP felt that it had no obligation to pay interest on the judgment, it had to raise the issue when the plaintiff moved for summary judgment, which clearly...
Well, I don't understand that to have been their position. I understand their position to be that they were required to pay only pre-judgment interest on the portion of the judgment that, or am I getting it backwards? Post-judgment interest. No, only pre-judgment interest on the portion of the judgment for which they were liable.
Are you referring to the supplementary payments provision in the ARCH policy?
Yes, yes, I am referring to that.
Okay.
That based on that policy, on that provision, that the excess insurer was saying that's all the interest we're responsible for.
ISOP raised that argument after the final order was entered. Before the final order was entered...
I understand that. That goes to your waiver argument.
Right, that goes to the waiver argument.
I was sort of following up on Judge...
Oh, just with regard to the language of the supplementary payments provision regarding prejudgment. That's what it says.
Right.
But doesn't the colloquy at oral argument suggest the same, that that was their understanding, or that was their position?
I'm sorry, at oral argument?
Yes, the colloquy at oral argument.
Yes.
Doesn't that help us to understand what they are saying is their position with this drop-down argument?
That was raised for the first time at oral argument. It wasn't raised in the papers at any time before that. I mean, the case law is clear that you can't raise issues for the first time at oral argument.
I understand. That was not what I said. My point was, didn't the oral argument help to clarify what their position was? Their position one being that it is not waiving their argument because it would have encompassed this position that they are not liable, or they're not responsible, to put it that way, for the interest that ARC would have been responsible for.
When the court discussed interest, ISOP made a one-sentence comment on the 1.3. On the 1.3 does not reflect the substantive issues that ISOP briefed after the final order was entered. It just said on the 1.3.
Doesn't that mean I'm not liable for the interest on the one?
That's correct. Raised for the first time at oral
argument. Isn't that close to the argument on it doesn't drop down?
Drop down with regard to 1 million. I don't think interest has anything to do with the drop-down provisions. The drop-down provision only has to do with ARCH's liability limit, which was clearly set forth in the declarations of its policy and in the declarations of ISOP's excess policy.
Chief, if I may.
Yes.
Yeah. So I just want to be clear about one thing. Are your post-judgment arguments and your pre-judgment arguments regarding to interest, do they rise and fall together, or are you making, can we look at them separately, and do you have separate arguments as to them?
Well, the pre-judgment, with regard to the pre-judgment, I'm sorry, you're talking about after the order was entered, or you're talking about just with regard to the issue of post-judgment interest and pre-judgment interest?
I'm talking about pre and post. Is it all one analysis? You get them all, or you get none, or part? Or is there a separate analysis for the pre and the post?
It can be a separate analysis. I mean, I can't, because the ultimate net loss provision in ISOP's policy cannot be reconciled with the supplementary payments provision regarding pre-judgment interest. ISOP is responsible for all pre-judgment interest. That's our position. And that's, I don't know if it's, I don't think it rises and falls together. I think post-judgment interest and pre-judgment interest are separate in this case. I think that if ISOP raised the issue at the appropriate juncture, maybe the argument would be different, but it didn't. And at page 333 of the record, it conceded that it had to pay the judgment less $1 million, not less $1 million and the supplementary payments provisions, which include pre-judgment interest. It didn't argue that, so it waived it. But if it argued it at the appropriate point, I guess it could make that argument, but I would say that it still wouldn't pass muster because it can't be reconciled with the ultimate net loss provision in its policy, which doesn't make any provision for pre-judgment or post-judgment interest.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. Elizabeth Alstrand for the respondents. Just to respond briefly about the reference at page 333, I think it's clear when you read our opposition to the motion for summary judgment in total, there is many statements that make our position very clear. At page 331, for example, we say, to the extent plaintiff seeks reimbursement of the entire judgment, his motion should be denied for the additional reason that the maintenance provision precludes ISOP from dropping down and satisfying that portion of the judgment that would have been covered by the Arch policy had it not been rescinded. It was our position throughout summary judgment and even before in our answer. The maintenance provision does not permit a drop down in these circumstances.
Counsel, I'd like to just move on a little bit to the substance of this, and
Sure.
particularly with respect to post-judgment interest. And as I read that provision in the Arch policy, it says, all interest on the full amount of any judgment that accrues after entry of the judgment and before we have paid, offered to pay, etc., the part of the judgment that is within the applicable limits of insurance. So as I read that provision, it seems to say to me, Arch will pay, and they'll pay all post-judgment interest, let's say on 2.3 million here, up to the point where Arch says, here's the $1 million we owe, right? And then they're done with interest payments. And that seems post-judgment. That seems reasonable to me, because why would they be on the hook for a secondary carrier's award after they've offered their payment? But Arch is gone here. So there's no way to stop, there's no one paying. So the secondary carrier can not pay on the judgment for years. That's being put on the Arch tab, but no one's going to pay that. So the way I read that provision, and this isn't a drop-down issue, but the way I think that provision could be read is Arch owes nothing here, right? Arch is out. So at the time of the judgment, Arch has paid everything they're liable for in the insurance, zero. And the clock starts to run on the secondary carrier for post-judgment interest. And wouldn't, as a policy matter, that make more sense? Because the way the thing is designed is if Arch was there, Arch could end that obligation, pay 4 days of interest and offer the $1 million, let's say. But now Arch can't do that because they're not a party anymore. So it seems like the effect of that provision should still hold because, you know, you're not dropping down, but, and why wouldn't you read that provision that way?
Your Honor, if you read it in isolation, that's a plausible reading. However, when you read it in the context of the ISOP policy, specifically the maintenance provision, which requires the maintenance of the $1 million limits, but also says that if you fail to comply with this requirement, we will only be liable to the same extent that we would have been had you fully complied.
And I'm saying you would be, because you're only liable for interest after the time Arch pays whatever it owes on any judgment. They owe nothing. So it's on your tab now.
Well,
and that's how this provision works. Even if Arch was there, let's say Arch went in, day the judgment came out and said, we're offering you, here's our $1 million judgment that we owe you.
I agree.
And you say, no, I'm not paying it. I want to do whatever.
Your Honor, I agree with you if Arch had stepped in and paid. It would be a different situation if the policy was still in effect. But the maintenance provision says our obligations are only going to be the same as if they were in effect. And if they were in effect, Arch would have paid the $1 million. Then you look to the next piece, which is you're saying that, well, Arch and our insured who is the one who resulted in the policy being voided for their material misrepresentations, that responsibility should shift to ISOP. But the insolvency provision makes very clear that your inability to pay, your primary's inability to pay, is not going to require us to drop down and pay anything in the insurance area.
But it's not a drop-down issue. I mean,
I agree with the judge. I think that his reading of it is closer to what I seem to see here. I'm wondering, it's not a drop-down. I wouldn't characterize it that way. It's straightforward interest provision that has strong public policy purpose to it. The public policy purpose is that the primary pays up so the excess can know what they have to pay and what it owes. But if the primary can't, then the excess is in essence stuck, not with what the primary owed on the principal, but it's still stuck with those interest provisions because of the follow the form section of the policy. It doesn't escape them because of that. Otherwise, it would have an infinity to pay. So
Well,
as
Your
a
Honor,
public policy matter, that makes sense, particularly with the language, it seems to have been designed that way.
Well, 2 points in that regard. For one, our coverage grant says that we sit on top of the ARCH policy, and there are 2 coverages the ARCH policy provides. It provides $1 million limits for bodily interest, and outside of those limits, it provides interest. So we sit on top of both of those. We can't be forced to drop down into either. The other point is that the public policy is really tied to the fact that the primary is going to be the entity that controls the defense, and they are going to be in control of the situation. And that control shifted back to our insured when that policy was voided. We didn't even get notice of the fact that ARCH had withdrawn its defense until after judgment had entered. That control never shifted over to ISOP. So the public policy piece really does not translate.
I'm not sure I understand, because I thought that there was, I thought that the primary carrier was out because of a material misrepresentation by the underlying insured.
Yes, and they brought a DJ that was affirmed on appeal, and
Right,
then they
and
withdrew their counsel.
you were familiar with all this. You knew all this was going on. There was no surprise to anybody.
ISOP was aware from a separate litigation that ARCH had filed a DJ. Neither ARCH nor our insured ever told ISOP that they had succeeded in that DJ or that they were withdrawing the defense. They were never put on notice of that.
I'm over here. Can I just clarify, because I think I may not understand what you claim you are liable for. I thought you were arguing that at the point in time when there is a judgment, right, that's when your interest clock starts ticking for everything that's above the underlying insurer, the primary insurance policy. Am I misunderstanding you?
Our argument is that our liability is exactly the same as it would have been had the ARCH policy been intact, because that is consistent with the language of the maintenance provision. And that is, we would be liable for the $1.33 million, pre-judgment interest on that amount, which is 100% consistent with the first clause of the supplementary provisions, and no prejudgment interest because the $1 million was never paid. ARCH obviously wasn't going to pay it because their policy was voided. But what normally happens in this circumstances is the insured steps in and they pay the money. And Cam Chung's inability to do that in this circumstance does not change the result. That's what the insolvency provision clearly directs.
But what I'm trying to figure out is the calculation of this interest. Does that not begin in terms of your liability at the point of the judgment?
In this case?
Sure, this is the case in front of us. I'll go with that.
Okay.
This is the policy we're trying to
So the way that, to move things forward, because this case basically stagnated after the May 2nd order on the summary judgment. Plaintiff submitted his proposed judgment, and our view of it was that it was an order that said we didn't have to drop down and therefore not responsible for anything within the primary area. He filed his proposed judgment, which was totally inconsistent with our reading of the order. We filed a motion to resettle, we filed another motion, we're here today. We, in connection with our second motion, also submitted a proposed judgment, and that judgment is what the court signed. And it provided that we would pay the $1.33 million, pre-judgment interest on that as calculated within the underlying case, and then post-judgment interest from the time that summary judgment entered in this case, and our liability for anything attached. Because there's a difference between what our insured is liable for and what ISOP covers, right? This is an action to collect on the policy because our insured didn't satisfy the judgment. But in order to get a collection from ISOP, plaintiff has to establish that it's covered under the policy, not just that from a global sense, they're entitled to that money from Cam Chung, our insured.
Let me just follow up on Judge Garcia's question in a little bit different way. He read you from the ARCH policy, 1, subparagraph G, but the preface there, right in paragraph 1, setting out ARCH's obligation, says that it will pay, and that would then pick up the post-judgment interest, in any suit against an insured which we defend. But they didn't actually defend this suit. So why do they have an obligation? Why doesn't that obligation entirely fall on you?
Well, Your Honor, that language has been, that wasn't really a focus in this case. Everybody assumed that Arch had this obligation, and it's never been disputed. And that's because in other cases that have looked at similar issues or have looked at that issue, it's presumed that that means that they would have an obligation to defend, that a defense would otherwise be required. So that the policy language doesn't change, for example, if the policy is voided or if they're insolvent. It's just more globally, would a defense be required under that policy? Because if not, then if a primary carrier wanted to avoid its interest obligations by wrongly defending, I mean, you would have a situation where, oh, you didn't provide a defense, now perhaps you don't have to pay the interest. And so that piece of the provision has not been interpreted to actually require the defense, but rather whether a defense would be owed under the policy language.
If I understood your earlier answer, if you had stepped in and assumed the defense, you would then not dispute that you would be liable for the post-judgment interest. If I misunderstood, let me know.
Well, this is an indemnity policy, so we didn't have a duty to defend. So had we...
I understand, but you were making a big point of the fact that you had no notice and you didn't actually have the opportunity to control the litigation in response to Judge Fahey's question about public policy. And so I'm wondering what you thought the import of your answer was.
Well, that was just circling back to the general sort of espoused public policy that's been articulated about the supplementary payments in general, because that provision has been interpreted a lot because it does put a big onus on the primary insurer. So it's been interpreted a lot to confirm that, yes, the primary carrier owes all the interest on the whole judgment, not just its proportionate share. But in terms of whether we would owe it at that point, I guess it would depend on the circumstances, because there's just a lot of variables there in the sense that the plaintiff was defaulted, and that's why the judgment entered in the way that they did, because they didn't have counsel, they didn't appear. So if we had appeared, who knows where the case would have even gone. So I'm not sure I can.
Your position is that you are responsible for post-judgment interest after a judgment was entered against you.
Yes, or if Camp Chung had stepped in and paid the $1 million, then absolutely, because the policy language clearly would have cut off the primary layer's obligation. Our overarching mantra in this case has been, we are only liable to the same extent that we would have been had the primary policy stayed in place. And that's the purpose of the maintenance provision and the insolvency provision. I can see my time is up. Thank you.
Thank you, counsel. Mr. Gorman?
Just with regard to the maintenance provision, ISOP's maintenance provision required the insured to maintain a primary policy with a limit of $1 million in coverage. There is nothing on the face of ISOP's excess policy that states that the insured was required to maintain the primary limits plus the coverage.
Well, but what about the definition of ultimate net loss and the general coverage provision, which incorporates ultimate net loss, which refers not to the limits of the underlying insurance, but to the underlying insurance, which when I look at the schedule of that in the excess policy, there are two columns. One is, this is the underlying insurance, and this is the limits of the underlying insurance. So they use those terms not interchangeably, it seems to me. They're two different things. So why?
The ultimate net loss provision in the excess policy, ISOP's policy stated that it was responsible for the ultimate net loss in excess of the Arch policy limits.
No, that's not how I read it. It says ultimate net loss is accepting, however, the underlying insurance. Whereas if you look at the maintenance provision, it refers to the limits of insurance.
The limits?
To me, those are two different things. The limits is the $1 million. The underlying insurance is the $1 million plus the supplemental, or whatever else is in the policy that we're not talking about right now.
Well, I'd like to refer you to the Second Circuit's decision in Home Insurance Company versus American Home Products Corporation, which we cited in our brief. And in that case, the excess insurer who followed form to the primary policy was not responsible for paying post-judgment interest on the award because the excess policy explicitly excluded interest accruing after entry of the judgment from the ultimate net loss. If ISOP did not want to...
Okay, but that doesn't mean that that's the only way to exclude it. Here, they excluded it by their definition of ultimate net loss, which was referring to the entire policy, which includes the supplementary coverage.
I did not see the ultimate, I did not interpret the ultimate net loss to encompass...
Well, that's clear from your briefing, that see, I guess that's what I'm asking you. Aren't you conflating two different terms? One term is the limits of the underlying policy, and the other is the underlying policy more generally.
Well, this was a follow the form policy.
I understand that.
And, I mean, no, I just want to refer you to Raggins, which we did not discuss. But in Raggins, the excess policy stated that HIC will pay all sums which are in excess of the primary policy limit that the insured shall become legally obligated to pay as damages. In this case...
Well, that's exactly the language that I'm suggesting may be missing here. It doesn't refer to the limits in this particular policy. It refers to
At
the
page 3,
underlying insurance.
I want to refer you to page 398 of the record. In this case, it has the same language. ISOP followed form to the Arch policy, and that policy states, it has the same language as the language in Raggins, that it will pay those sums that the insured becomes legally obligated to pay as damages. There's no distinction. And like the policy in Raggins, ISOP's excess policy did not mention interest as a covered sum of damages, and ISOP's policy did not limit the definition of sums to any particular category of damages or exclude interest.
Counsel, I'm sorry, Chief, may I?
Yes.
Counsel, what post-judgment interest has the defendant agreed to pay, and what are they contesting? Post-judgment interest.
The post-judgment interest that they paid was after, they paid post-judgment interest on a portion of the judgment.
Which portion?
They paid a post-judgment interest on, I believe, $1.5 million. They're responsible, it was our position that they were responsible for paying post-judgment interest on the entire judgment.
But I thought they only paid us a certain, let's say it's the 1.33, but let's say I thought they only paid a portion of time post-judgment interest even on the, let's call it the excess award.
They did.
And what was that period that they paid, and what didn't they pay?
They paid from May 2016 to June 2017 on, I believe, approximately $1.5 million, which brings it up to about 1.7 million.
And what does that period represent?
I'm not sure. I don't know. I don't have an answer. I don't have an answer to that question. I was never able to figure it out. I don't know why they paid it.
Thank you, counsel.